Okay. Let me make sure nobody's on the other side. They're supposed to be over here. Yeah, there is. Good. Judge Williams in that fussing. Okay. All right. We'll now call our June 13th, 2022 meeting to order. Let me take a moment to welcome everyone here. Let us do self-introductions in any order. Don't be shy.
Corey Austin, County Commission. Glad to be on. Thank you, Madam Chair. Good to see everyone.
Thank you, Commissioner.
Good afternoon, everyone. My name is Alona Holmes, and I'm here on behalf of the NAACP.
Hello, everyone. I'm Colonel David Holmes. I'm the Executive Director for the Broward County Sheriff's Office, Department of Law Enforcement.
Elder Geis, Faith Community.
Elijah Williams, Circuit Court Judge, Delinquency Chairperson. Madam Chair, can you see my face?
Yeah, so we can see you.
Okay, because I have a split screen. They just put a new screen in. Okay, thank you.
Gordon Weeks, Public Defender's Office.
Major Victor London, Fort Lauderdale PD.
Valerie Wands of Broward County Public Schools.
Good afternoon, Cassandra Evans, Chief Probation Officer, Department of Juvenile Justice.
Good afternoon, Johnny Sanders, Delinquency Prevention Specialist for the Department of Juvenile Justice.
And those that
David Watkins, Broward County Public Schools.
Preston.
Is that everyone?
Director of External Relations, DJJ.
Welcome.
Yolanda Brown, Court Administration.
Welcome. Thank you, Ms. Brown.
Thank you.
Is that everyone?
Madam Chair, can you hear me?
I can hear you. I just hear you as Yolanda Brown.
Oh.
Are you able to change your name?
Yeah, I can try. I don't know how that happened. Okay, thank you. Gloria Michella on behalf of the State Attorney's Office. I'll do that now.
Alrighty. So we want to be reminded of our norms. Cell phones placed on silent or vibrate. Raise your digital hand if you would like to be recognized to speak. A maximum of 3 minutes per person unless you are presenting. We're going to respect all others' opinions and viewpoints and address all board members and visitors respectfully. I will now entertain a motion to approve the agenda as presented.
So moved.
Second.
It's been moved and seconded. Is there any on readiness? Hearing none, all those in favor, let it be known by the sound of aye. Those against nay. Ayes have it. Let's go to an update. First of all, Mr. Watkins, I think you and Dr. Wands have been moving around, so you kind of switched roles or added some roles or took some stuff away. So if you'll just tell us now what your role is. I mean, you told us some different things and you'll use a lot of words. So what does that mean as far as how you have worked with the DJJ and this board over the last couple of years or several years? I know you've worked in different capacities, but where are we now? Mr. Watkins.
Okay, I'll go first. Thank you, Madam Chair. So my previous role as Director of Equity and Diversity included the overseeing the education of youth who are in the juvenile justice facilities, as well as providing support to youth who are in transition through the 17th Judicial Circuit Juvenile Division. My role is now transitioned to oversee the discipline. That includes expulsion and abeyance. It includes the student code of conduct, and it will continue to include the programs at Pine Ridge, such as Promise, alternative to external suspension. And I will also continue to oversee our initiatives around diversity, which include, our equity work and some of our diversity mandates.
Can you tell me who now, as far as disciplinary matrix and that committee and code of conduct, who is now overseeing that?
So for now, that will be, I will be overseeing it, but the position, the person who was overseeing that is no longer with the district. And so we're in the process of filling that position.
Okay, so temporarily, until that happens, who is in charge?
I will be that person.
Okay, thank you. Dr. Wanza.
Good afternoon. So in the reorganization, all of the DJJ programs and oversight have now come to me. So the principal at Whitten Rogers will oversee the school-based programs. So the teachers at the detention center, at the youth treatment center, who would normally, and the assistant principal, Miss Merchant, will now be under Whitten Rogers, but as their own school within a school, as they were some years past. And then the courts liaison individuals transition, they are administratively under me, housed here in Pompano.
Thank you. On the school-based data, we had a couple of questions that were to be researched because we received the data so late last month. Chief Evans, did you have an opportunity to review the report and determine if the, in a deeper dive, were the district numbers and DJG's school-based arrest numbers pretty much the same? Or do you remember what the difference was?
Madam Chair, unfortunately, I have not had an opportunity to dive deeper into that. There was nothing, but I can say there was nothing startling in the numbers as a subset of our data set. But no, I haven't had an opportunity to do that. And I do know that Mr. Walker is no longer in that role. So I would need to connect with the new liaison to have further discussion.
And the new liaison, I'm sorry, did you say that was you, Mr. Watkins? I'm sorry, I didn't hear that.
Yes, I'll be the liaison.
Okay. Moving forward. Okay. And I don't know if I know you were moving things around. Did you have an opportunity to review the data? And are you, do you have any concerns about whether the school-based arrests are truly school-based arrests based on the way the district sees it?
So that's what I'm in the process of doing now, is just sort of, once getting settled and, beginning that process of reviewing the data and getting a sense of what is, what is happening. And hopefully by, next month, I'll be in a position to really kind of, give an update on what my perception is of the data that we've captured.
Okay. We also asked the colonel and the major to double check whether or not there was a practice in place of arresting students at school who had been accused of committing a crime in the community. Colonel, did you have an opportunity to check with your folk? Is there a practice and or a policy?
Yes, Madam Chair, I spoke with our captain that oversees our school resource deputies, and most of the arrests amongst the juveniles occur out at the residence or in the community, more so in the schools. Our policy, as far as the deputies making arrests in the school, we have to work hand in hand with the state's attorney's office to make sure that probable cause does exist and that a serious crime had been committed, and that we go through our standard protocols as far as civil citations as well. But according to my captain, most of the arrests are, to be honest with you, most of them tend to be domestic related out in the community as far as, at the person's residence.
So Colonel, let me ask it in a question in a different way. Is, to your knowledge, or did you ask if there was an occasion where a child had been accused of a crime committed in the community, that they would then go to the school and arrest that child for the crime that they were accused for committing in the community, not at the school? Will they go to the school and make the arrest, was my question.
That has happened, but we don't do that often. It's normally at the residence. If it's a serious crime in nature, where there was serious bodily harm or something that is elevated to a crime where we can't wait until we come in contact with them at the residence, then yes, it would happen at school, but that's very rare.
And how would that be labeled in your system or in DJJ's system if the arrest occurred on campus for a crime that they were accused of off campus?
Yes, we would classify it as a felony arrest because it would have to be rise to the level of a felony.
It would be considered a school-based arrest if the child was arrested on campus, but was arrested.
If the crime, even though they were taken to custody at school, if the crime was committed outside the school, it wouldn't be considered a school-based arrest.
Colonel, I'm sorry, Chief Evans, how does DJJ log an arrest that happened at school, but for a crime that they were accused of off campus?
Our database differentiates the arrest location versus the offense location. So we're able to see, and then of course we know the address of the school. So we're able to see the difference of the two in our database.
But is it
a question a different way? Madam Chair, is it okay if I ask the question? So when they are taken into custody, where is it? Where's the ping? Is it because they were taken into custody at the physical location of the school? Does that show up anywhere on a report?
The offense, which is the offense, the rest of it shows, that address shows up. There are about 4 or 5 different addresses in our database. That's one separate than where the arrest took place. So the example given, Dr. Wanza, would be, into the chair, would be the child committed a burglary with a firearm in the community. He is been identified and may be under consideration for multiple burglaries of that level. The young person goes to school X. Law enforcement has cleared their protocol. They go to the school to take this student into arrest. We're going to identify when the police report is submitted to the department, the offense, which would be the burglary with the firearm, that arrest will be captured. Then you have the arrest location, which will be the school. That's captured in a separate data set. So the system can see that they're not at the same, that this didn't happen on campus and the child was not arrested on campus, so that they would not be equal. The question,
in your database, is this considered a school-based arrest? Has that been changed in the system? Because
I can't speak to that because I have never looked at a data set to ask that question. So I don't want to speak to a query that I've never reviewed to see is this occurring. So I don't see why it would be a school-based arrest because the definition has not been met, that the offense itself did not generate from a school-based incident, which is the basic definition of a school-based arrest where you check it off in JGIS, that wouldn't have been met. But I have not looked at any data, Madam Chair, so I can't quite say with any degree of certainty.
So why is it, I'm sorry, Matt.
Go right ahead, ma'am. Go ahead, Doc.
So why is it, and I'm just following that logic, when the burglary or whatever occurred near to the school, but the closest address that they identify is the school, and that has happened, where things have happened in the vicinity of the school, but the closest physical address they can identify is the school. And then it gets pinged as a school-based arrest when it's really not a school-based arrest, but because the address of the school was used as the, you know, the closest address they can find.
I'll defer to law enforcement as the author of those reports.
Yes, if I may, Madam Chair. Very similar to what Ms. Evans stated, we will look at the offense location or the offense location and where the subject was taken in custody are two different addresses. They would differentiate. Unless the offense took place at the school, then it would be a school-based arrest. If the offense took place at the school and they were being charged with the crime, because that's where the location took place, the incident took place, then that's where they would coincide. But as far as offense, if the offense took place in Cooper City, you know, at a mall or whatever, and we were able to apprehend the subject at the school, no, that would not be a school-based arrest. They would be taken into custody at the school, but the offense would be the mall in Cooper City.
So if they got caught doing something illegal in front of Cooper City High School at 10 o'clock at night,
well,
literally on the sidewalk in front of the school, but the address is in front of Cooper City High School, so you use Cooper City High School's address.
If the offense took place on Cooper City property, that would be the location. That would be a school-based offense. If the offense took place on that property.
Okay, well, we have an issue with, we've had that in the past because I know that there were a number of school-based arrests that were listed as school-based arrests, but they were actually not what you described as school-based arrest. It didn't happen at school. And I know for a fact that Fort Lauderdale, and I'm going to defer to the major, and you said you would check to see. So I guess we can do that now. Major London, does Fort Lauderdale still have a practice, or do they have a policy that either one or the other, they're not necessarily the same thing, of arresting children at their school for crimes that they have been accused of committing in the community?
I'm so tempted to say that I'll defer to what Colonel Holmes said, but I know that won't make you happy.
Mm-hmm.
That's
So if you forgot to ask, please say I didn't remember to find out. Please say that.
No, I did. I don't forget anything dealing with.
When you check your policy, what did it say?
So let me answer the question as asked. It is not a practice, but it's not prohibited by policy to do so. In my inquiries with the people who make the juvenile arrests, it's not something that they would typically do. If it is necessary, and that's the only place they can locate them, then it will occur. And I think the issue of counting the school-based arrest is an IT issue, because it should be data capturing the information that you want to capture to give relevancy.
Okay, so yes, it does still happen, and you all don't have a policy against it. I'm just, we feel some sort of way about kids getting arrested at school, but we can't, we're saying to the district, school-based arrests are up and school-based arrests are up, but that may not be the case if you have arresting kids who did not commit on-campus crime. So that certainly is still a concern.
Well, I just want to be specific. I think what we're trying to measure is, are kids being arrested in school more, as opposed to do the police department here at Fort Lauderdale have a practice of using the kids' requirement to be in school as a shortcut to arrest them, and that's not necessarily a practice. though if it's serious enough, it can occur because they need to put the public safety at the forefront.
So that's found, if you have to do that, but then it should not be listed in anybody's database as a school-based arrest. It could be an arrest at school. We get that. But we're talking about the issue, how it's being logged. So when we look at the data, we want to make sure that everything, when they say school-based arrest, is that a legitimate school-based arrest? That's what's the issue.
Yeah, I agree with you. That's why I said it's an IT issue. That if we're trying to capture the times that kids were arrested in school for doing something on campus and it's school related, and that's the measure, then it should be captured at that as that. But if it's a law enforcement arrest for something that's got nothing to do with the school campus and the offense, then I would think that the data should not be counted for that measuring point.
Let me ask you, would you go on to campus to locate the kid for any arrest? Clearly, if it's something that is a felony, it's serious, that sort of thing, then that makes sense. But if it is a misdemeanor, and would there be any occasion where your guys would go on campus to arrest the kid?
But it would have to be something significant and serious. And it would definitely be a felony.
Judge Holmes?
I think what precipitated this concern is something that happened in Coconut Creek, where the kids were sort of bickering among each other in class. It died down. The teacher was able to get control. After school, they walk across the street to the mall, and the other children who were offended followed them. A fight broke out at the mall, and I think Major London hit it on the head. The police went and made arrests, and because it was related, he used the word related to something that happened in school, it went down as a school-based arrest, which leads to discipline up to expulsion or suspension or whatever. So my question is there a way to segregate that? And from what I'm hearing, we can't get around that if the police are going to say it was related to something that happened in school. If related is the next nexus, is always going to go down as a school-based arrest, when in essence something else happened at the mall other than what occurred in school, and it escalated to a physical fight. So I think Chief Evans, do you know anything about how they can segregate this out or determine if it's two different addresses, even though it happened near the school, that the location of the arrest, in that instance, it would control because it happened at the mall. But if they were arrested at school, that seems to be the controlling factor, and is going down in databases as a school-based arrest.
Yes, it will be the verbiage in the arrest report that determines if the department identifies it, through the database system. So if, again, to use the term, the relatedness, if that is related back to the school campus, is going to meet the minimum definition for us of the school-based offense. And if the narrative of the arrest report, if it is absent of that, then it will go down just as an arrest in the community at said arrest location. So, but I think the other question is, of those arrests that have already been attributed to the school board, is there a way then to look to see if the point of arrest is different than the school system, and then to take a deeper dive and to see if those are cases that are being described here, right? Because you've got what we can do going forward, but you also have a data set now that may be of concern. So that's what I'm hearing.
Yes, correct. Because we've had that issue in the past, and I know that it's a matter of where, if they had an argument at school and it carried on, and if it happened on the bus, we get that. If it happened on a school bus or school trip, we get that. A football game, we get that. But when the officer decides to go to the school and pick up the kid, we just want to make sure that the district is not being credited, if you will, for school-based arrest. And that, to me, that certainly skews the data. So I can't say to Dr. Wands that your numbers are up when actually they may not be up. And some of those that have already been labeled are not necessarily so. I know we've had the discussion many times before, but we just want to be clear of what a school-based arrest is, so we'll know exactly what that is. And I know that Major London was not in his current position when this practice started happening, but I know that there have been officers with the city of Fort Lauderdale specifically that said that, well, I don't have to chase them. I know they'll be at school. I'll just go there. And so they've gone and picked up kids and go, and you can attest to this, put the little kid, and I'm not talking about killers or murderers or anything like that, in the back of the police car and taken them from their middle or elementary school in handcuffs in the front of everybody from their schools. And those are our concerns that we will, since there is new leadership, we need to address that as well. Mr. Weeks.
Most definitely. It's always a matter of policy, practice, data. The bottom line is we need to be able to monitor when children are actually being arrested in school. And because of all this gray area, you can't really get a proper hand on it. So I appreciate that we're having this conversation. I mean, I know it seems, that we're drilling down on this particular issue, but these are the things we have to drill down on so we can get a real picture of what's happening in our community. So I appreciate the work of the board for asking these questions, and more importantly for the agencies and DJJ for being able to provide some answers and some guidance. What we should do is try to, now that we recognize this issue, is try to find some policy adjustments to make sure that we are properly capturing. Something happens outside of a school, and I understand Dr. Wan is 100%. And I don't want to belittle the work of law enforcement, but I know sometimes you're looking for a landmark to lock off where the incident occurred. And if that school's a landmark and it really ain't occurring in the school, then we getting skewed data on our end. And, this is a matter of having a conversation, elevating the conversation, and then hopefully it will work towards the officers that are in the field to understand why it's important to accurately, reflect where these things are occurring. Appreciate the conversation.
Well, we don't have to go and get the baby from the middle school or elementary school and put them in the back of the car in front of their friends. We could probably find another way to find them, Let's go on to the, Dr. Wanza, so are you now in charge of the students that are in custody, in DJJ custody over at the detention center?
Yes,
Is that your wheelhouse?
Yes, ma'am.
Okay, thank you. All right, update on the Broward Jack civil citation stopgap and Fort Lauderdale jail. So we'll start with Colonel.
Yes, Madam Chair. As far as any issues or concerns, we had one issue that was corrected over at our at the Jack with one of our deputies there that issued a citation, a civil citation, and I guess one of the jurisdictions didn't agree with it. So we went back and forth with that, but we got that addressed. As far as the personnel over there, they're still on board and understand what our proper protocols are. And our biggest thing, and it's been this way since the beginning, is making sure that those few jurisdictions that hasn't been on board with what we're trying to do eventually comes on board. If they don't, we're going to continue to have issues where we may have an officer from a particular city that we're used to dealing with become defiant once again. And that's what we don't want. And then hopefully we can correct that. We've gone to the Broward County Chiefs of Police Association numerous times. I know Ms. Evans and I both talked about that in front of all the chiefs, but we still got to get them on board, to alleviate that problem. So that stopgap measure has been working. But every now and then we come across a conflict like we had not too long ago. So we're just keeping our fingers crossed. Any support that we can get from you, Madam Chair, and other members of the board, the State's Attorney's Office, the Public Defender's Office, where we can come and unite to make sure that these other municipalities get on board. I highly suggest that.
Thank you. And may I ask, without asking the department, how was that issue resolved? Were you forced to process the kid, arrest the kid, or were you allowed to issue this civil citation? This is looking sad, so you know.
We issued the civil citation, but I don't think it was accepted.
Cassandra, Chief, what was your recognition of?
I don't understand.
Do you recall if the civil citation was not accepted and you all were forced to arrest the kid?
I'm not familiar with the situation, so I'm not sure of the case you're speaking of or the scenario, so.
Okay.
Ms. Evans, I will get with you off record and
okay.
Discuss the details.
Okay, absolutely. Thank you.
One of the common cities that we've dealt with in the past.
So Colonel Holmes, thank you for that. If you're speaking to what I'm thinking of, then it was a young person who was eligible, arrived to the JAG. Your team member said, hey, let's do the civil citation. Their officer declined. They proceeded.
Correct.
And if your belief it was not accepted, that means the young person was processed. So
correct.
It was the arrest.
Yes.
Okay.
Yes.
Okay.
Exactly.
Okay. And their chief was at the meeting, the chief's meeting when you all went to speak through your call?
I can't quite say.
Is that
if they were, I can't say who was present at that meeting.
Okay. Thank you. Let's go to Fort Lauderdale's jail. Major.
Yes, ma'am.
Gap for juveniles at your jail. Is that working?
Yeah, if they qualify for the juvenile civil citation, they don't come to the jail.
Okay, and you can say with certainty that not one juvenile who qualified for civil citation was booked through and processed through your jail.
I didn't say that. I said if they're qualified, they shouldn't go there. We did have a missed opportunity based on a report that was shared out for May and June, but there are explanations for it.
Okay, so you're saying it was you all dealt with it and the child did not qualify, or where was the error, or was there an error?
As it relates to the officers,
missed opportunity.
Yeah, we're going to go to that part now. So as it relates to our 3 incidents that we have, one was a miscommunication from what I understand from reading the report with the officer contacting the JAC and being told that the kid wasn't eligible. And then once they did the transport and arrived there, it was determined that the kid was eligible, but the kid was still processed and it was approved by the duty lieutenant. Another set.
I'm sorry, hold on one second. You said the duty lieutenant approved the civil citation eligible child to be processed, or he approved that to let Colonel Holmes' staff give the child a civil citation?
You keep adding on, Madam Chair. I said what I said. So
what you're telling me is your stopgap ain't working. That's what you're saying.
But what I'm saying to you and what I've always brought forward was that the duty lieutenant will be the impartial decision maker for the officer who might be impassioned to want to follow through with something that is not prevented. So the duty lieutenant, here in the circumstances that were presented, gave the officer the approval to proceed without doing the juvenile civil citation, which is part of our policy.
Is there a disciplinary, or is there still a disciplinary policy for those folk who do not follow your direction, as opposed to just nothing happens.
In this case, that wouldn't be applicable. I'll go back to what I said initially. The officer was initially told that the kid was not eligible. Once they got to the facility, it was determined that the kid was eligible, but the officer asked our duty lieutenant whether or not they should proceed with the arrest, and the duty lieutenant said proceed with the arrest. That's per policy and it's acceptable. And given
And
the
so y'all okay with that? That's what I'm saying. You deny your department. Let me finish. Your department, based on what I'm hearing, your department via your lieutenant was okay with a child being arrested, even though they were eligible and by your own policy should have been given a civil citation. Y'all all right with that, is what you're saying?
Well, I was gonna elaborate a little bit more, but what I will say is with the circumstances that were presented and with the information that was shared with the duty lieutenant, they felt that it was proper for the child to be arrested. There are more extenuating circumstances to where even if the child was eligible initially at the scene, that they probably would have been transported based on our procedure because of the age difference involved with the victim and the suspect. So there's other stuff that you need to consider when we talk about elevating the decision-making to the manager level as opposed to the officer level. So with that, I'll go to the other two, which involved vehicle burglars who were arrested for prowling. And based on the information there, no issues based on the situation occurring in the middle of the night, trying to do felonies, got caught on a ring camera, subsequently arrested. So I don't have an issue with that. And the last one involved a juvenile who battered his mother. So it was domestic related.
Yeah, I was more concerned about the first one. I understand about the other ones. I think we talked about that. I was concerned about because there used to be a different policy in place, very much similar to what SO has. Matter of fact, SO initially designed theirs after Fort Lauderdale's, but I understand there's a regime change. So that means that we're not where we were supposed to be.
Let me just clarify. This policy that we're talking about is the same policy that we worked with you on and you approved. So it didn't change.
No, what you did was a copy and paste of the state attorney. The one that I worked on with the previous administration was not similar to what you described.
No,
it was not.
It's the same policy, trust me.
Yeah, that was the action that was taken under the previous regime would not be the same. We've had a number of, you would do things differently, but I do understand that was 85 chiefs ago.
We're using the policy that you blessed, Madam Chair.
No, what you're using is what you went with the state attorney. You said this is a copy and paste. The one that we have was different from that. And there was a disciplinary piece and there was a discussion held. If there was one that got a missed opportunity, there was a discussion of how we got there and what decisions could have been made. So that doesn't seem the same thing that you were describing, but you know what, I'll take a look at it then and now, because
it's the same one. And as we talk about it, is you got to understand that even that policy that we looked at together, it allowed a duty lieutenant the option to deviate. So that means the officer was compliant with policy.
I understand that, but there's policy and there's practice, and the practice was not the same. That's what I mean. Okay. Fort Lauderdale, I got y'all confused with Coconut Creek there for a while there, brother. That was disappointing. Okay, so let's go on to any questions. Let's do that. All right, let's go on to what's happening with the clerk of the court. Any update on that, Ms. Machella?
Specifically with regard to?
Has anything changed as far as the stopgap that you were going to look at? I think we talked last month about possibilities, whether there was a way to put a stop, or there was to wait to carry out the agreement that was originally reached regarding those eligible, civil citation eligible cases that reached their desk. And I think Judge Holmes had made some suggestions.
So I think the last meeting that we had, you had mentioned that Miami's clerk's office did have an agreement or an arrangement with the state attorney's office with regard to holding cases in abeyance for the state attorney to review them in case they were eligible for civil citation. I am currently communicating with the Dade SAO right now to understand that practice so that I can figure out what it is or how it is that they're doing it with the clerk's office and what cases, what types of cases, not types of cases, but the manner in which those cases are getting to the clerk's office and then how they're getting held. I'm using the term in abeyance before they get assigned a case number. I'm trying to understand their best practice so that I can see if we can try to implement that here. So I am in communication with them. I have not been able to, I have additional questions and we are back and forth on communication with that right now so I can understand it.
Okay. I've not seen that. Judge Holmes, I know you brought that to the table. Have you actually read Kathy Rundle's policy on that?
No, I've been in touch with the gentleman that spoke on the forum that we had. And so I need to take a trip down to Miami and just sit across from him. And I mean, the way he explained it at the forum that we had a year and a half ago was that the police send the probable cause affidavits to the clerk, but the clerk sends it to him. He reviews them, but he explained that he's up all times of the night. Whenever a juvenile is arrested, he gets called. And so he's able to look at the probable cause affidavit and make his argument as to why this child should not be, arrested. And so they have a system in place where the police don't take them to COTE or to one of the jail facilities. So I want to get his step-by-step, and I'll write it down and give it to you. I had been meaning to go down to Miami, but hadn't gotten down there from my last meeting last month because I've been in and out of town. But I'll get there before the next meeting.
Okay, thank you. Any questions, concerns? All right, we will go to back to Ms. Marcella. If you had an opportunity to meet with Coral Springs Plantation and Lighthouse Point regarding their internal exclusions, preventing issuance of civil citations.
We had met with Coral Springs. I have not met with Plantation or Lighthouse Point.
And Coral Springs is not budging?
No, we had a very good conversation or discussion with Coral Springs. I think Coral Springs is definitely on board with utilizing civil citation in every situation that they, I was encouraged that they will utilize civil citation in every situation that they can. Again, barring any discretion that law enforcement may have, depending on circumstances, but the conversation was encouraging that they'll utilize it even more than they have been.
Are they willing to adjust their SOP to come in line with your, with the state attorney's civil citation? Because they had some extra stuff in there.
You have an example?
Can I make I'll give you an example. They're one of the jurisdictions that arrest for loitering and or prowling under 856. So they don't care about civil citation, and that's one of the most arrested offenses of juveniles, loitering and or prowling. And they get it wrong. And if the judges would just read the case law, I think the case came out of Jacksonville, and read that and start throwing out enough of them, they'll stop and they'll give a civil citation as opposed to an arrest. The arrest is a precursor for something else.
I haven't actually seen a lot of loitering or prowling arrests in quite a while. I haven't seen them on the missed opportunity reports. I think they've gotten the message on that. We very rarely, if at all, file loitering and prowling. I'm well aware of the case law that with regard to loitering and prowling, so they're not really reaching judges because we're not
But they're
filing.
still being arrested for it though,
I'm
which is
not
what we're.
seeing that.
going
I
away.
mean, if somebody wants to show me the cases where we're still seeing a lot of LMPs, I am happy to look at that. I can tell you from the discussion with Coral Springs, I don't believe that they feel they are using loitering and prowling anymore as a precursor or utilizing it as much as they did in the past. But I'm not seeing anything in the missed opportunity reports that are showing me a lot of LMPs. I'm not seeing it. I usually
You're
look at
seeing
those.
some?
No, I haven't seen any really in a while, but I do follow those monthly reports just to see what types of arrests we're seeing. And I have not really seen any LMPs, but certainly if anybody's seeing them or Chief Evans sees them and she highlights them to me, I'm happy to look at it, Ms. Gaynor as well, but I'm not seeing that. I think we've gotten past that. That's why those reports are helpful, because it gives me an idea of where we're still at with regard to missed opportunities. But I do think that the conversation and listen, going forward, we're going to know as we see these, continue to see these reports. I do think the conversation with Coral Springs was very encouraging, and we're going to see a lot more buy-in from that agency, as well as Coconut Creek, because we had that really good meeting with them as well. So the devil will be in the details. I mean, if those reports should bear that out. If there's not a reasonable explanation as to why law enforcement officer might be still not issuing a civil citation, or it's not one of those ineligible offenses, we're going to know, and I'm going to be I look at those every month. So, but no, I have not seen LMP.
Okay, when we get to Ms. Gaynor report, which will be shortly, we'll be able to go over those the issues that we had with those exclusions from their SOPs. Let's go, which is right now, let's go to Ms. Gaynor regarding your missed opportunities report.
Excuse me, Madam Chair, Judge Williams had his hand up.
Oh, I'm sorry. I apologize, Judge Williams.
Yes, Madam Chair, just please give me a little bit of lenience. I'm covering for Judge Robolo. Two things I just want to quickly say. I saw my first loitering and prowling today, and I have not seen one in 6 months. And I even made a comment. Boy, we're starting to go back to loitering and prowlings. I'm looking at the case now on my docket, and I'm trying to find out which department it is. The name is, well, you can look it up, Ms. Michelle. It's 21-2124. The last name is Irvin, E-R-V-I-N. But Madam Chair, just give me 2 seconds. Here's my concern. The first issue, and I apologize, I couldn't find the chat setting to raise my hand on this thing, and neither could my J8. But back to the first issue. Every day I do 2 to 3 pickup orders. About 10 to 15 a week come out of my division. A pickup order is an arrest. It's just the juvenile term for an arrest. When you take a look at the other 4 judges, of the 3 judges, we're signing 40 to 60 arrest warrants, pickup orders, you can call them. My question becomes, we're not including those arrests in their school-based report, are we, Ms. Evans? So pickup order arrests at the school are not being included in that arrest count, are they?
No, sir, they're not captured that way.
Thank you, thank you. I'm sorry, Madam. Thank you, Madam Chair.
That's a good question, Judge. Okay. All right, Ms. Gaynor, would you like to share?
No.
Okay, go right ahead.
All right. So the missed opportunity report, I think the last time we met, we had April. So I have both May and June to report this month. There were 11 missed opportunities in both months. There were a total of 45, however, 23 were ineligible offenses such as domestic violence, and there were a couple of weapon offenses. So we had 22 true missed opportunities. There were 11 for each month. And in that report, in those 2 reports, there were actually 3 loitering and prowling. I was listening to the major kind of cover his missed opportunities. I'm not sure if there is an error in the data, but there are 2 loitering and prowling for Fort Lauderdale. And this is just a matter of someone selecting that in the system. So I think we probably need to look at that a little bit. The majority of the arrests were for assault and or battery, there were 13. 1 for disorderly conduct, 3 for loitering and prowling, 1 for obstruction of justice. There were 3 petty larceny and 1 for trespassing.
And give us the breakdown, if you will, please, by police department.
Okay, there were 5 for BSO, 4 for Coconut Creek, 4 for Coral Springs, 4 for Fort Lauderdale, 3 for Margate, and 2 for Plantation.
Okay. Major, are you unfamiliar with the data that Ms. Gaynor has provided?
Yes, it's the same data I shared earlier, where the ones that were associated with the burglaries were the loitering and prowling.
Okay.
Okay.
The ones who were there at midnight, breaking into cars.
Okay. Colonel, do you need to, I don't know if you got this report earlier, do you need to get with your people and then let us know?
Hello, Madam Chair. No, I have reasons for 5. I have 5 right here in front of me. I can go over each one really quickly, if that's okay with you.
Please.
All right. There was the first case. It was missed opportunity, but it really wasn't, because it was a battery case that resulted in serious injury. It was a sizable chunk of flesh taken from someone's face. So that wasn't a missed opportunity in that battery. The second one was sexual in nature, where a juvenile violated another juvenile sexually. The third one, the individual was part of a auto theft ring. They were stealing vehicles, and this individual was caught, and they were afraid that they would continue to be a part of that ring. And a huge investigation started, especially from our specialized unit. We have a burglary apprehension team that targets auto theft rings, and this individual was part of that. So it's a huge investigation that resulted from that. The fourth one, it was a battery. It was a fight that took place, and then the juvenile threatened to go back to that residence if given a civil citation. So that's why that was a missed opportunity, but it really wasn't. We didn't want to have to go back to that location after the juvenile threatened to return. And the last one, it was documented as a battery, just a simple battery, but the deputy wrote down the wrong charge. It should have been a battery with injuries. Should have been a felony. Should have been upgraded to a felony. That was a mistake by the deputy that has since been corrected by the command staff. And those are the 5 missed opportunities that we had.
Thank you. Ms. Gaynor?
Yes, I just want to request, Colonel, if you could, we can't do anything about it in the civil citation end, but maybe on the report, on the missed opportunity report, if you can have Ms. Evans, who can direct it to her staff, to note that it's some kind of way is sexualized in nature, because had that been on the report when we received it, we would have just noted that as an offense that's on the report, but that's ineligible due to our circuits plan, because that is an exclusion.
I apologize. I will make sure that that's taken care of. I'll make sure our staff is aware of to inform you of that.
Right, but you can't, so you can't put it in the system, but maybe Ms. Evans' staff can assist with that.
Okay, we'll work with her staff to make sure. Thank you.
Thank you. Ms. Martella?
So I had an opportunity to look up the loitering and prowling that Judge Williams mentioned. That was actually a pickup order from a case that the youth was diverted on last year. And also a grand theft auto was a second pickup order, and he might have been picked up on the same date for both of those cases, but those were not current arrest cases.
Okay, any questions on what we've covered? Does that conclude your report, Ms. Gaynor?
It does. I know last time we discussed it, and I'm not sure in the listening to the conversations how accurate this would be, but on the missed opportunity report, there are 12 that are noted as school-based or school-related.
Well,
12
that's
of the
certainly
12
important.
12 of the 22.
Yeah, that's pretty important. And if you could probably give us some more, not at this time, but maybe at a later day, give us some more detail so that Dr. Wanza will be able to determine, is this really school-based or what this, what that looks like. So she'll be able to speak to it when we discuss that with her. Because we will be meeting with the superintendent regarding this whole piece. So I wanted to, she'll defer to Dr. Wanza and she'll need to know what's going on with that. So I really appreciate that.
Okay, I will.
Okay. Anything else on that topic? Okay. Circuit 17 CAB chair. I received a notice from DJJ saying that I have termed out and I need to vacate and we need to elect another chair. I have until the 29th of this month to vacate. So we need to discuss electing a chair.
If I may, Madam Chair.
Yes.
First, no one can ever vacate you from anything. You've been with the DJJ advisory board for what has it been, 10 years, 15 years now, doing a lot of good work in this community, elevating a lot of issues, holding a lot of folks to task. And I think that's very important. So I want to thank you for your service and all that you've done with this board, creating a board that has input and influence from all of the key stakeholders that affect juveniles in Broward County. And that took a lot of work to build the network of folks to get things done. So you should be thanked and commended from DJJ. They should be giving you a plaque. Where's your plaque? No plaques? But nonetheless, if it is statutory and required, I see a lot of folks that have great interest in this. And I see no one other than our friend and our formerly recently retired judge that would make an awesome chair for this board. If she would be kind enough to accept my nomination for her to be the chair of the advisory board, I would be more than inclined to nominate her as a chair for this advisory board.
Judge Holmes has been nominated.
I'll second that.
Moved and second. Are there any other nominations?
Oh, that was fast.
Are there any other nominations? Are there any other nominations? And nominations are closed. All those in favor of Judge Holmes being elected to our new chair of the DJJ Circuit 17 Juvenile Justice Advisory Board, raise your hand, say aye, all of that good stuff.
Aye.
Is there anyone against? So let the record reflect that Judge Holmes has been unanimously elected to chair a Circuit 17 CAB. And so I will certainly send that in. My official last day, Judge, will be the 28th. I will send in all the information and I'm certainly, I'm here. And so we will certainly continue. I won't have a vote, but I can certainly provide input. So I want to, that we certainly appreciate your stepping up. As always, I know she regrets she ever, one of those people that regrets I ever got her cell phone number because I'll blow her up. Major London, you can relate to that. Judge Holmes, Colonel Holmes, we just had a conversation the other day, with some stuff. Our commissioner, county commissioner, Alston, we got stuff. So, she's one of those folk that we call on, and it's nothing new and certainly not new to work. So if you would just say a couple of words, Judge Holmes, greatly appreciate it.
But first, let me say, Madam Chair, thank you for your service to this very, very important board. I didn't realize all of the issues in Broward County that dealt with our children. As I said when I first got on this board, I did not sit in the juvenile division, but I handled a lot of juvenile cases, especially a lot of direct files. So I'm familiar with the statutes that concern the children and the rules of procedure. So I do thank you for your diligence. I mean, 10 years, that's a long time. To the members of this board that voted for me, thank you. I appreciate your confidence. I may not know a whole lot of stuff, but I'm a quick study. I read at night. And I have a t-shirt that says I read and I know things. So, you know, I'm willing to work hard. I'm passionate about those things that involve the children in this community. And so I will do my best. I'm open for ideas and suggestions. Thank you all again. I appreciate it. I didn't get that prayer in Reverend Geis. I was trying to get it. You were saying, was there any word from the Lord? Thank you all.
Madam Chair.
Yes.
If I can say a few words. Words can't express how much I appreciate all the hard work that you put into making sure that we did things the right way. You held us accountable. I think society needs more people to be held accountable. And if these juveniles only knew how much time and effort you put in to making sure that things were done properly, they would be surprised. I can't thank you enough. I learned a lot from you. I know you're still going to be a part of the board, but what a great leader you are. And I just want you to know that it will never, ever be forgotten. I appreciate you so much. And on behalf of the community, we thank you. And you know, I'm glad you're still on the board. So I could still, my ear's still open. I'm still accepting that knowledge. So, but I wanted to thank you. And I know we're in great hands with Judge Holmes. You know, great name.
Thank you, Colonel.
We're still here, and we're all about doing the right thing. We're all about doing the right thing. But thank you so much. Thank you, Madam Chair.
I appreciate you.
So my question is now, will you be, Madam Chair, coming on saying you're representing the NAACP as a panelist?
I will absolutely be here. The only thing I won't be doing is voting. That's all. Ms. Phillips.
Yes, I first of all want to say thank you for all you have done over the years. And I have to tell you guys something, the reason why she was coming aboard and didn't find it robbery, because actually I talked to Marsha a few years ago and she wanted no parts in the beginning and stepped to the plate because I kept bugging her and saying, listen, we need you. And she turned me down quite a few times, but
tell them why.
Well, I'll let you share that.
They weren't doing nothing. That's what I said.
She was talking much seriousness about how she felt then. And that's why I told her we need her aboard as we were moving forward. And, you know, I have loved working with her. And yes, we have had a lot of battles and she's very persistent, but it is worth it for our kids. And like I said, she didn't find it robbery. She never lets go. She holds us all to task. And I think as Colonel Holmes said, that's what we need because we're fighting for our kids and it's a nonstop job. And so I want to personally thank her for her commitment to our community and our kids. And I also want to say to Judge Holmes, yes, I am so happy that you are aboard and we are 100% behind you in whatever role we get to play because, you know, our work is yet begun. So thank you both.
Thank you. Major London. You're muted, sir.
I was just extending my thanks to you,
sir.
I thank the judge for stepping up, and I do appreciate you and all your many capacities.
Thank you so much, sir.
As you often say, in the fight you remain, and I appreciate you for that.
Thank you, sir. I appreciate it. Mr. O'Bell.
Madam President, thank you for your years of service. And thank you personally for when I first jumped on board, just guiding me through some of the process and the bureaucracies and so forth. I know come December to the board, come December, there will be a special honoree award from Madam President from Community-Based Connection. She'll be being honored with the Green Blazer Award this year for her work in terms of fight for social justice for the community and kids. We look forward to honoring you. Speaks as a true testament of what you have done here in Broward County. And we want to continue to do that great work alongside of you. So thank you for your years of service. And Judge Holmes, thank you. I'm ready to serve at your pleasure.
Thank you, Mr. O'Bell. I appreciate it.
And I'm driving, for those like, why he ain't showing his face? I'm driving from the Florida Children Coalition in Orlando. So please forgive me.
Thank you. I know you go to that every single year. Okay. Let us go now to COVID-19 Juvenile Detention Center. Anything that you can add, Chief Evans?
No report on any COVID cases, Madam Chair.
And there's no, you're not on lockdown or anything like that?
No, ma'am, not to my knowledge.
Okay, thank you so much.
You're welcome.
Colonel.
Yes, Madam Chair. We currently have 8 juveniles at our Paul Ryan facility, 1 at a North Broward Bureau for a total of 9. We have 0 COVID cases at those locations where our juveniles are housed. They all have access to mental health services, and none are positive, and they're all wearing masks is strictly enforced at this facility. So that's a good thing. Overall, in the jail facilities, we have a total of 89 positive inmates. That's all the facilities together. But as far as the juveniles, we have 0 positive cases. So we're working hard to keep it that way.
I have to reach out to both you and Mr. Weeks regarding an issue that is COVID related. That is a serious concern, but it does not involve children. It involves an adult and a person who was forced to stay way too long because of some COVID issues. So I will certainly be in touch regarding that. We really hate to get these calls from parents regarding these issues. And so, but I will definitely be in touch with the both of you. I believe, is there anything else? I think there is an event coming up with the Black Policemen's Association, the Juvenile Youth Summit that's coming up tomorrow. I did talk to the immediate past president, Nina Justice. Ms. Evans, did you get a call from Nina Justice regarding information regarding some of the DJJ's kids and participating in the program?
No, I have not. And I know Ms. Justice as well, but I did not receive a call from her.
Okay, so if she has not, she will, you can expect a call. They are doing some Black Policemen Association, Fort Lauderdale Black Policemen Association are doing some good work, and they want to extend that as well in order to try to work with our children.
Okay.
Any announcements? Any?
Just
right.
clarification, Madam Chair, the event is on Friday, not tomorrow.
Oh, I'm sorry. I was thinking it was Thursday. You're correct. And I'll send out the flyer as well. I did get it, and I'll send it out to all in our network. Thank you, sir. Judge Holmes, I'm sorry, Judge Williams.
Yeah.
Just Judge Williams. I saw his hand first.
Yes, let me just go ahead. Ms. Ellison, I just want to say that I appreciate the fact that you recognize that in order to run this race, we have to have the right horses in the race. And what you've done to put the right individuals in the right places particularly the Black judges, keeping us in place. I just want to say thank you very much. And I shall personally, not professionally, never forget what you've done for us. And Judge Holmes, thank you once again for stepping up to the mantle. I just want to encourage everyone. Judge Ross, and this is for the good of the order, found out that a child was calling from the detention facility around midnight, past the 10 o'clock p.m. lockdown. She discovered that one 12-year-old child was like being bunked with the 17-year-old kid at the detention facility. And there was a chaotic situation. She was receiving information. So I made a trip out there. It was around 10 o'clock on a Friday night to check things out. And it was pretty much okay, a lot of staff around. I would encourage everyone here to use your authority to go inside the detention facility, to just walk around and go like at odd hours when they least expect you. You know, Abraham Lincoln said that a commanding chief has to go to the front of the lines to see what's going on. Superintendent Roselli, I found out, had been out for a while, and there's a temporary person there who's doing a good job. But let me just encourage all of you. I've encouraged my staff in my courtroom. My other judges are going to be going out there at odd hours to just kind of keep an eye on the place. Again, I can't get a sense of what's going on, but I think it bears close watching. So I would encourage everyone. I love Superintendent Roselli, but apparently he's been out for a while. So all of us should be walking over there, exercising our statutory authority, which I think we fought for like 3 or 4 years ago. We got there. We just walk into the facility and ask to walk around. So thank you very much, madam.
Judge Holmes.
I have a question for Chief Evans. I read an article just recently that there's been some changes in the Florida probation system to allow remote hearings, remote appointments. And if you don't have it, I'll send it to you. But I wanted to find out, does that extend to the juveniles that are on juvenile probations?
Madam Incoming Chair, if you elect, if you would be so kind as to send me that article, I will have our general counsel advise me properly on that.
Because that way, when rather than to say they didn't appear, they just call on their phone. Yo, what up? I'm appearing, or something like that. All right, so I'll get that to you. Anybody else that wants a copy of the article, I'll be more than happy to send it to you.
Thank you, Colonel Holmes.
Yes, I don't think we talked about this, but there's been a significant change in the juvenile system in reference to House Bill 7029 that was just went into effect July 1st, which states that judges will be able to hold juveniles in custody for serious offenses from arrest until trial. That's huge as it affects juveniles. Also, the judges may also order that a juvenile be placed on supervised release with electronic monitoring without a time limit on monitoring period. That's going to affect all of us. The Florida Sheriff's Association has reached out to all the sheriff departments throughout the state and asked for assistance with implementing this House bill. You know, we're not sure how each agency is going to support what's taking place, but I think it's important for all of us to be aware of these changes that have taken place. And I think that our youth and their family members need to be aware of it too, because if not, there's going to be a lot of shocked people and we're all going to hear about it. So this is the route that the state is going, and just so everyone's aware, they're asking for the sheriff's departments to be on board with them. And it's not that everyone agrees, but that's the way that they're going. So I just wanted to bring that to everyone's attention that may not have heard about it.
Thank you, Judge Holmes.
If I could just address that, I read the bill, I'm aware of it, but I had not spoken to Mr. Weeks about the constitutionality, because there's some Supreme Court case law that talks about, US Supreme Court case law, that talks about monitoring as being a search under the Fourth Amendment. Also, judges have always had the ability to hold anybody in jail. I mean, I know we get the 21 days, you know, if a juvenile is arrested and the department shows up, judges have always been able to hold, but the legislature just decided to codify because a lot of the appellate courts were reversing the lower courts. I myself have held juveniles in custody for offenses, and the state made eloquent argument to do so. But that's 6 on one hand, half a dozen on the other, because it gave the state time to direct file or to waive them over as adults. But some of the crimes just can't be helped. But there is a constitutional component that the entire bill may not be constitutional. So I don't want to get too heavy. I was just going to take Gordon to McDonald's. I'm on a fixed income, and so and get him a Big Mac and some fries and talk about that legislation. So anybody want to join me, you can come, but I'll have to buy you a Happy Meal.
If I may, Judge, we have been exploring the issue and preparing for it, and there's briefs already ready and hot, waiting for the right fact pattern, the right case, so we can challenge it. This is a statewide issue. Everybody's watching it, and once we get the right fact pattern, create some good law, we'll challenge the issue. But I will be more than welcome to any other legal insight that folks may have, because the more good scrutiny eyes you have on it, the tighter it makes the arguments.
And Elijah is laughing because he can't say a word about it.
That's correct. But Judge Holmes, I will say this. I've always never could figure out how Dade County was able to hold individuals indefinitely until their trial date. I mean, they have guys down there for 4, 5, and 6 months. So I think you're correct. I just could never figure out what legal theory Dade County was operating on.
I got some case law.
Chief Evans.
Two things. Thank you, Colonel Holmes, for raising that point. I've already been in contact with Director Scharf as to what our partnership will look like going forth. Fortunately, our numbers are very small. At this juncture, about 47 kids in secure detention and about 12 kids or so on electronic monitoring, maybe another 12 on supervised release. So our numbers fortunately have been low at Broward County, but he and I and his team have been in communication, so we will certainly move forward as necessary. But secondly, I wasn't sure, I don't see Mr. James on, but there's an event coming up also, Madam Chair, and to the board. I will send that flyer to you for, this is the second workshop in our series. So the first one was Know the Law, and that was hosted by the State Attorney's Office. And this one will be not hosted, but facilitated, is a better word, by the Public Defender's Office on, save the date for Tuesday, August the 2nd at the North Branch Library, which is the one on Broward College North Campus. And it will be from 2 to about 4:30. And it'll be the Know the Law series. And so we will distribute, last time we had about 60 young people and parents in the room. Coconut Creek brought their entire, their basketball team. And they were very engaged, extremely engaged. Great questions. And we had about 5 vendors out. We expect to have at least a half a dozen, if not more, vendor resources out, as well as then this presentation. Our young people had the opportunity to earn up to about 15 hours of community service, and they got a chance to really meet the decision makers and ask those tough questions to those who really make the decision. So to Madam Chair, outgoing as well as incoming, I will share the flyer with both of you all.
Thank you.
You're welcome.
Thank you. Anything else for the good of the order? And we were speaking of going to the facility. I don't know when the last time, Doc, you've been out, but and I know that you would have like David and Williams would be out frequently. So I would encourage you to work with your staff that are out there, because they'll be the first ones to know when something's not going well, and they would, if they would share that with you so you can start working on it, because things, sometimes the training goes off the track out there, but we want to make sure that they are in an environment that is not only safe, but that is clean and sufficient so that they can do the job that you're sending them there to do.
So if I may, I have the fortune, I don't know, from the late 90s of being the assistant principal over that program. So I certainly have very fond memories and not so fond of that time. And then the 3 years when David was still at Whidden, and I think 2 of those years I was your director, right? When you were still the principal over. So I understand completely, Doc. Madam Chair, President, well, you always be Madam President to me. So I get the titles confused, but understood completely.
Thank you so
And
much.
so yes, the school is under me. The Director of Teaching and Learning over the principal is Ms. Eckhart. So she and I will be very involved.
Okay. Thank you much. I appreciate that. And John James is on. He's incognito today. But so he is on. I'm not sure what's going on with that. I'm going to report him to his boss after this call.
He got approval, Madam Chair. He's traveling.
Okay, he got approval not to say hello. I don't really know how to take that, but okay. Anything else for the good of the order?
He's a good man. Go light on him, Madam Chair. and I'll just add before
is this a new thing we have in here as a
I
council?
tell you, the commissioner is on. All right.
Well, Madam Chair, before you close, I'll just tell everyone there is only one Marsha Ellison. And I think everyone has said we appreciate all that you do, both for this board, the local NAACP, and the state. And I'll just make everyone laugh here. I think we all agree. We definitely want Marsha on your side and not the other side when you're in a battle. So thank you, Madam Chair, for all that you do. And thank you also, Judge Holmes. And of course, we look forward to your leadership.
And I'm glad you said that, because I noticed in a lot of the thank yous and the press conference and everybody and the Lord got thanked, which is fine with the Lord, but the county didn't get thanked for the money that they put forth for civil citation, and they continue to do. And we have asked Commissioner Alston to stay with us and not let them take any of our dollars and keep staff on board for this very important work. And he continues to do just that every single day. So we want to thank you. I thank the county for its continued contribution, and thank you for making sure that our dollars for civil citation and helping in juvenile justice, helping these kids, has not been reallocated to someplace else. So thank you for coming in and hitting the ground rolling.
Absolutely, Madam Chair. In this public forum, we're waiting for the county budget to be presented from the county administrator. So I'm hoping that it reflects what we talked about. So more to come. All
right. Thank you so much. And with that, all hearts and minds are clear. Thank you so much. Until next time. Meeting is adjourned. Thank you so much. Bye-bye.
Bye-bye.